Welcome back to the deep dive. If you've ever sort of puzzled over how a big, diverse country manages to pass national laws when you've got, what, 9 distinct provincial governments also needing a say? Well, it's not just about reaching a friendly consensus.
No, absolutely not. It really comes down to procedure. Very rigid procedure, in fact.
Right, that complexity of balancing the central government with all those provincial interests, huge. And when national laws get drafted, the provinces have to have their voices heard. But crucially, that voice needs to be, officially okayed and certified.
Exactly. And that certification process, how a provincial legislature actually gives its representatives the thumbs up to speak and vote nationally, that's defined by our source material today. The Mandating Procedures of Provinces Act 52 of 2008.
Like 52 of 2008. Okay.
Yeah, this act is basically the legal rule book. It governs how a province's political stance gets turned into an actual countable vote at the national level. It's the absolute bedrock.
And it's not some dusty old law either, right? This was assented to early 2009, started officially July 2009.
Correct.
And we're highlighting that because our sources show it was checked for updates really recently, March 2025. So this procedure, it's still very much in play. It's active.
Absolutely. It's continually relevant. So our mission today really is to lay out what this act does, its purpose, and how it works in practice. We want to get past that general idea of, oh, the provinces get a vote, and dig into the specifics.
The real nuts and bolts.
Precisely. Think of the act as like a legal firewall. Guarantees that a national vote can't happen unless the province's position has gone through this very specific mandatory paper trail.
Okay, let's unpack that then, starting with the big why. Why this whole act just for procedure? Can't they just, I don't know, send a quick email saying, yeah, we're good with this?
Well, the short answer is consistency and legitimacy. The core purpose, stated right in the act's objective, is to provide for a uniform procedure.
Uniform procedure.
Right. Yeah, uniform procedure for the provinces to give their delegations to the NCOP, that's the National Council of Provinces, the official power to cast votes. Without that uniformity, you'd basically have, well, chaos, 9 different ways of doing things.
And here's where it gets really interesting, I think. This need for a standard rule book, it's not just about keeping things tidy bureaucratically. It's actually a constitutional requirement, isn't it?
That's exactly right. It's a non-negotiable legal demand. The preamble of the act itself, it explicitly mentions the need to enact the legislation that Section 65 AT of the Constitution called for.
So the Constitution literally said you need to make a law about this.
Pretty much. This act exists because the country's foundational legal document demanded it. Connect that to the bigger picture, and the underlying goal is really accountability.
Accountability how?
Well, if you're one of the 9 provinces, you need to be sure that the other 8 are playing by the exact same rules when they authorize their people to vote. This act guarantees that. It ensures all 9 provinces follow the same procedure for giving the NCOP delegation the go-ahead, and that applies across the board all provincial legislatures and the NCOP itself, as Section 2 states.
Right. So we get why it exists, standardization, constitutional need, accountability, but giving authority, it's not just one simple act. We need to kind of demystify the jargon, especially around the different types of mandates. This is where it can get confusing.
Absolutely. It's crucial to understand the hierarchy here. The key players, of course, are the provincial delegations to the NCOP. They're the ones actually representing their province nationally.
They're the boots on the ground.
Exactly. And they're the ones who need this official authorization to act.
And they get different kinds, these mandates. Let's break down the 3 main ones. Maybe start with the broadest category, the legislative mandate.
Okay, yeah. Think of the legislative mandate as this sort of master permission slip. It's the really fundamental authority given to the delegation.
For the big stuff.
For the really big stuff, yeah. Voting on major constitutional questions, think amendments, or bills that fundamentally change how national and provincial governments relate. Sections 64, 74, 76, 76, 78 of the Constitution cover these. It's the highest level of legal authority they can receive.
Okay, so that's the top-tier permission. But then you get into the day-to-day business of legislation, which involves, well, negotiation.
And that brings us neatly to the second type, the negotiating mandate. Now, what's really interesting here is the difference in who grants it.
Ah, okay.
This mandate isn't given by the entire provincial legislature. It's conferred by a specific designated committee within that legislature.
A smaller group then.
Right. And this mandate, defined in Section 5, it gives the delegation their operating instructions for negotiations. It sets the parameters for when they're in the NCOP select committee meetings.
So it's like, okay, team, go in there. Here's our starting point. Here's how far you can bend. And here are the specific changes we want you to try and get.
That's a great way to put it. It's the pregame huddle guidance. It might even include specific proposed amendments. And importantly, it has to follow the format laid out in Schedule 1 of the Act.
Schedule 1. Got it. So they negotiate using that Schedule 1 mandate. Then presumably, once the dust settles and a bill is kind of ready for a final yes or no, the province needs to issue its official binding decision. That would be the final mandate.
Correct. The final mandate, Section 1 defines this, is the authority given by the full provincial legislature. The whole House signs off.
So not just the committee this time?
No, the entire legislature.
Yeah.
This is the decisive step. It grants the delegation the power to cast the province's definitive vote when the NCOP Select Committee formally considers the bill, just before it goes to the big vote in the NCOP plenary.
And this one has its own format requirement, Schedule 2.
Exactly. Schedule 2 format. So
Yeah.
you've got the negotiating mandate from the committee using Schedule 1, setting the negotiation boundaries. Then the final mandate from the full legislature using Schedule 2, giving the binding official position.
That makes sense. It's a two-stage check. The delegation gets some room to maneuver in committee, but the final say has to come from the whole provincial parliament.
That's the core check and balance right there. It ensures proper internal sign-off.
Now, you mentioned Schedules 1 and 2, the formats. The legal side here sounds really strict, and the actual physical paperwork seems incredibly important. Let's dig into the how specifically. What does Section 3 demand for that crucial final mandate? You said 5 things.
Yes, 5 specific requirements. And these are not just suggestions, they are absolute legal prerequisites. Get one wrong, and the mandate could be invalid.
Okay, what are they?
First, it must be on the official letterhead of the provincial legislature. No just typing it up on plain paper.
Adds that official weight.
Precisely. Second, it has to clearly state the name and the number of the bill being voted on. Zero ambiguity about which piece of legislation this mandate applies to.
Makes sense. Third,
It must state the actual vote. Is the province voting in favor of the bill, against it, or abstaining? It has to be explicit. No vague language.
clear direction. And fourth,
This is critical. It needs the signature of the Speaker of the provincial legislature, or alternatively, someone officially designated by the Speaker or the legislature to sign off on that specific bill.
wow, okay. So that signature is the legal proof the whole legislature is behind this decision.
It's the guarantee.
Right.
And finally, fifth, the mandate document must be formally addressed to the chairperson of the NCP or their designee. And again, it absolutely must follow that prescribed Schedule 2 format.
Think about that. You forget the letterhead or the designated signer is out sick and someone else signs it. You could potentially invalidate your entire province's vote on a major national law.
It really underscores how much power rests on getting the procedure, the form. Exactly right. It's not just red tape.
Okay, so the speaker or their designee signs the final mandate, locking in the legislature's position. But then who actually gets up in the NCOP plenary session and physically casts that vote for the province? Is it still the speaker?
That's a really important distinction and quite a fascinating separation of powers built into the Act, specifically in Section 4.
Okay.
What stands out is that the executive branch gets involved in the final physical act of voting. The Act says the vote must be cast by the premier of the province.
The premier, the head of the provincial government.
Yes, the premier, or a delegate specifically chosen and designated by the premier for that task.
Wait a second. So the legislature decides the vote through the final mandate process we just discussed.
Correct.
But the premier, the head of the province's executive branch, is the one who actually delivers it. That seems potentially tricky. Isn't there room for friction there? The executive casting a vote dictated by the legislature?
It might seem counterintuitive, but it's a very deliberate institutional design. It actually forces cooperation between the branches.
How so?
It creates a clear two-part chain of accountability. The provincial legislature is accountable for deciding the province's political position. That's their job, reflected in the final mandate.
Oh.
Then the premier's office, the executive, is accountable for accurately executing that position on the national stage. It ensures the head of the provincial government is personally involved and responsible for delivering the legislature's instruction.
Huh. Legislative authority, executive execution. I see. Okay, so we know there are different mandates. When are both that detailed negotiating mandate and the final mandate absolutely required? Is it for every single bill?
No, not for everything.
Hmm.
The Act in Section 7 makes it very clear. Both mandates, the Schedule 1 negotiating one and the Schedule 2 final one, are specifically required for bills referred to under Section 76 of the Constitution.
Section 76, those are the bills directly affecting the provinces, right? Things like shared powers, provincial funding, structures.
Exactly. Bills that have a direct impact on provincial powers, functions, or boundaries. And they're also required for certain types of constitutional amendments under Section 74, particularly those affecting the provinces or the NCOP itself.
So basically, any major national law that significantly touches how provinces operate or what they can do, those must go through the full, rigorous two-step mandate process, committee negotiation, then full legislature sign-off.
Precisely. It builds in the maximum level of provincial scrutiny and internal agreement before that final vote gets cast nationally. It's for the really high-stakes stuff.
Right. And this brings us to the very last step in the procedure, which clarifies this other term, the voting mandate. So the full legislature signs the Schedule 2 final mandate. How does that piece of paper actually translate into the premier standing up and saying yay or nay in the NCOP plenary?
Good question. The voting mandate is essentially the final go-ahead, the execution order. Section 8.1 lays this out. The provincial legislature confers authority on the head of its delegation, typically the premier or their delegate, to actually cast that final vote in the main NCOP plenary session.
Okay. But wait, didn't the legislature already give its final say with the final mandate? Why need another mandate just to vote? It sounds a bit redundant.
But this is where some procedural efficiency kicks in. The Act anticipates this. It recognizes that often, after the final mandates, the Schedule 2 documents are submitted and discussed in the NCUP Select Committee.
Yeah.
If those discussions don't raise any new major issues, if nothing comes up that really needs the provincial legislature back home to reconsider its position.
Then you don't need to go through the whole process again.
Exactly. Section 8.2 provides a shortcut. It says if the NCOP committee deliberations on the final mandates don't necessitate further review by the province, then that province's signed final mandate, Schedule 2, is simply tabled in the NCOP plenary as its voting mandate.
I see. So the final mandate becomes the voting mandate automatically if no major changes occurred during the NCOP committee phase. It streamlines things.
Precisely. If the negotiations stayed within the parameters the legislature already approved and the bill wasn't significantly altered in committee, the signed Schedule 2 document serves as the authorization for the premier or their delegate to just execute the vote.
That avoids dragging the whole thing back to the provincial capital for another round of approvals. Much more practical.
Definitely avoids unnecessary delay while still ensuring the final vote aligns with the legislature's ratified position.
So let's pull this all together. What does this mean practically? If you're, say, a law student studying this or someone working within these structures, why is it so important to get the difference between Schedule 1, Schedule 2, who signs what, who casts the vote? Why does it matter?
It matters because the Act is fundamentally about formalizing checks, balances, and accountability. That's its real value.
Okay.
The negotiating mandate, Schedule 1, makes sure the delegation doesn't go rogue in negotiations. They have clear committee-approved instructions before they even start talking.
Right. Keeps them on mission.
And the final mandate, Schedule 2, guarantees that the ultimate decision rests with the entire elected legislature, not just a committee or the premier acting alone. So when a province votes nationally, you know that position has been through a rigorous, accountable, and crucially, uniform process across all 9 provinces.
So, recapping the key takeaway. This act ensures the voice of the provinces in the NCOP isn't just some arbitrary opinion. It can't be just the premier's view. It has to be backed by this specific, standardized, formal paper trail involving committees, the full legislature, and finally the premier's office for the actual execution of the vote.
Exactly. Which leads to maybe a final thought for you, the listener, to ponder. Consider the sheer power of form and procedure in lawmaking, especially in an act like this.
How so?
All those detailed requirements we talked about, the official letterhead, the specific signatures needed, the mandatory formats in Schedule 1 and Schedule 2, they seem like minor bureaucratic details, right?
Yeah, easily overlooked maybe.
But they're not just boilerplate. They are the absolute legal guarantee of legitimate provincial consent at the national level. Think about the political chaos or the legal challenges. If someone could prove a province's crucial vote on a major law was invalid simply because, say, the mandate form wasn't signed by the correctly designated person or it wasn't addressed properly.
The entire law could potentially be challenged?
Precisely. How much legal power rests purely on getting a signature right, on using the correct schedule format? The answer is potentially immense. It could impact the validity of the entire piece of legislation. It shows procedure isn't just process, it's power.